Welcome everybody to the presentation today. We wanted to thank the authority from Connecticut Society of CPAs for putting on this presentation for us. You will be getting CPE for this. There are polling questions to track your participation. And if you have any questions, reach out to either us or the authority, and that should be it from us.
Great, thank you so much, Aubrey. So thank you all. I am Erin Choquette. I'm the General Counsel for the Connecticut Paid Leave Authority. We're joined here today by our CEO, Andrea Barton-Reeves, as well as our COO, Chris Floyd, and our Executive Assistant who's running the controls, Amber Forrest. I'm going to share my screen in just a moment. Just a quick housekeeping details. We are recording this so that we can share it with Connecticut CPA associations so that you can see this again. We can share the slide deck with you as well. And as Amber's putting into the chat, if you could introduce or submit to us your questions through the Q&A function rather than the chat, that'll give us a chance to keep track of the questions better and make sure that we respond to everything. Great. I'm going to share my screen.
And Erin, I just want to interject. Hello, everyone. We're happy to be here. I think there's a question from the group. If you can put the question in the chat, we can respond to you. Thank you.
Okay. I'm just going to try and reduce the static here. Maybe that'll be a little bit better. Okay.
Yeah, so thank you for the person that raised the issue. We did let Erin know that there's a lot of static with her connection, so we're just trying to resolve that now.
Okay. So Chris, as we said, Chris Floyd is here. She's our acting Chief Operating Officer who is running our operations here at the authority after spending more than 20 years in various healthcare and health insurance businesses. And I am an attorney working for the authority after spending 14 years at the Department of Administrative Services, and prior to that, almost 10 years in private practice. So we've got a lot to do, so we're just going to jump right in. We're going to talk a little bit about—
Erin,
yes.
I'm sorry, your connection is still really bad. So I don't know if we can go through the whole presentation. Do you want to, I know you had a lot of trouble signing in. Do you want to sign out and sign in again? Do you want one of us to get started while we fix it? Because I think it's going to be tough for the next half hour.
Okay, so my suggestion is that Andrea, either you or Chris, let me stop sharing my screen.
Okay.
So you guys could take over sharing the screen, and I will, if you want to start, I will do my best to get back in under a better scenario.
Okay.
Okay.
Chris,
And
do you
just
mind
give
sharing
me
your screen?
Yeah, I will. Just give me a minute.
Okay.
Sorry. Let me try and get out of this.
Okay, if I can just, if someone can confirm if they can see my screen.
Yes, I can.
Wonderful, thank you.
Great.
Okay, and I will be in slideshow mode. Okay, can you still up? Okay, and someone just sent a poll. Okay.
Yeah, first, for continuing education, you have to.
Okay,
participate in it. Right.
Wonderful. Thank you. So thank you, everyone, and thank you as we've just pivoted to just change who's presenting. We will spend some time today talking about the background of the program, key dates. We'll talk a little bit about the background of the leave laws, which will Erin will help provide some context to. We'll talk about the role of the employer, how to plan to applying to paid leave benefits, and then background around the private plans, and then finally around how to register your business. So the mission of the Connecticut Paid Leave Authority spawned out of 2019 when the paid leave benefits came into law for 2021, and was seen out of an advocacy need around seeing the growing needs for families and needing to have financial relief in taking care of their families in critical times of family events and needs for care. And family members need the ability to do this, to be able to support their families. Okay, my apologies. To support their families without having to worry about lost income. And so as an authority, we are an entity that is here to be able to provide that pathway for support, and then also to help inform employers and administrators and healthcare providers around what are the tools and resources to support the workforce in navigating how to use the program and these associated benefits. In doing that, our authority came into launching last year. Our CEO, Andrea Barton-Reeves, came on board in March of last year. And we have formulated our work around 5 work streams that are helping us to get all of our work in place. One around outreach and engagement, where we are working with community organizations, trade associations, organizations like yourselves, where we can help share the message about Connecticut paid leave, and we can reach out to the organizations about sharing the information about the program, how it works, and making sure that there's awareness around what Connecticut paid leave offers. We are a startup agency, and as such, all of the policies and procedures around how we will operate are being formed, and we are working to set that up within our organization. As I mentioned, we are a startup agency. There are only 9 of us right now, and we're working with a wonderful technology partner, but we're putting together all of the policies and procedures around how we will administer claims, how we will collect the contributions, which started as of January 1st. Those contributions that we are now starting to collect through employers, we have the responsibility of having those funds come into a trust fund. And in that also, per the statute, we also have that fund defined in context with the contribution rate, which is defined statutorily, and we will collect and receive those contributions in a secure manner. We have a close partnership as mandated through the statute with the Office of the Treasurer. A unique and defined trust fund has been developed that will collect those funds, and that is part of our operational procedure. We also have the responsibility for those employers that will seek to go with private plans to be able to review and approve those on behalf of employers. And again, by statute, they have the option to offer that to their workforce, but should they, we will review and audit those on a periodic basis. And then finally, going into 2022, we will have the responsibility for administering the whole claims benefit process for leave requests. So who is covered and who is not covered? By the statute, it is defined that employers that have one or more people that are working in Connecticut are covered within the Paid Family Leave Act. This includes nonprofit organizations and private sector employees with unionized workforce. We do have the provision for sole proprietors that have the provision to opt into the program should they choose to. If they do choose to opt into the program, they must participate for a minimum of 3 years. And the same thing for self-employed individuals that have that choice for opting in. Who's not covered are employees of the federal government. Many of the employees of the state of Connecticut, except as to covered public employees, the municipalities, unless they are been specifically indicated as covered public employees, and then local or regional boards of education, unless, again, they have covered public employees. And then non-public elementary or secondary schools are not part of the program. Erin, I see you now. I don't know if your audio is better or I didn't know if you were trying to interject.
Well, let's try. I'm finally back into the meeting. So
oh, you're clear.
Can you hear me better now?
Much better.
We can hear you clearly.
Terrific. So I'm happy to take over my slides if you like.
Sure.
Chris,
Okay, and I'll just.
Yeah, could you just put it on to display for slideshow as opposed to presenter view? Because you're seeing the next slides.
Yeah.
Sorry.
Okay, never mind. We'll just won't worry about that. So the covered public employees. So as Chris said, most employers are covered, but the statute does exclude certain groups of employers. But even those employers who are excluded have the opportunity to participate. So if you're a covered public employee, you may participate in the program. And that includes the non-unionized employees of the state of Connecticut, so managers, appointed officials, legislators, and the like. Unionized employees of the state who collectively bargain to be included in the program can join in. And then with municipalities and local and regional boards of education, if the unionized staff collectively bargain to be included, then everyone comes in, both union and non-union. So although the program is primarily intended for private sector employees and managerial level employees of the state, unionized employees can participate if they choose to. Next slide. So just a quick slide just so you can understand the life cycle of the contributions. Contributions started as of January 1st, 2021. And so employers are required to process the employee contributions. Our program is entirely employee funded. So the employee actually contributes 0.5% of their wages. But since the employer handles processing of payroll, the employer is one responsible for doing the calculations and remitting the contributions with some basic wage information to the Connecticut Paid Leave Authority. We validate that information and we immediately put the contributions into a paid leave trust, which is overseen by the Office of the State Treasurer, but it is not considered to be state funds. It is a dedicated account. It cannot be used for any purposes other than administering the program and funding the benefits. The two big questions we get about contributions are how do we calculate them? And are they capped? And so they're calculated the same way that you would calculate your employees' contributions for purposes of FICA. So all the wages you include for FICA, you'd include for us. Anything you exclude for FICA, you exclude for us. The contributions are post-tax, which means that they don't reduce the employee's taxable obligation. So you do your calculation for FICA, say it's 100,000, and then you take the 0.5% off of that number. And they are capped at the Social Security contribution limit. So any earnings above that limit, which is currently 142,400, I think, we don't receive contributions off that fund. Next slide. So just to help put everything in the context of the existing leave laws, we wanted to really give everyone kind of an understanding of where Connecticut Paid Leave Act fits. Because there are a lot of laws already that provide job protected leave, and there's really not many laws that provide income replacement other than workers' comp, which is limited to on-the-job replacement or on-the-job injuries. In terms of job protected leave, however, there's a lot of laws, including the federal Fmla, which applies to employers with 50 or more employees, the Connecticut Fmla, which has been on the books since 1996, but will undergo a major change next year, which I'll talk about in just a moment. Workers' compensation, the Americans with Disabilities Act, the Pregnancy Disability Act, and the Connecticut Fair Employment Practices Act all also provide some level of leave as our job protected leave. For the ADA, the PDA, and CFPA, leave may be considered a reasonable accommodation for an individual with a disability. For workers' compensation, there are rules under the workers' comp laws that prohibit an employer from terminating employees simply because they're injured. And then, but the role of the Connecticut Paid Leave Act is to help provide income replacement for people who have a right to take job protected leave under one of these other laws. It also provides income replacement for individuals who can't work even if they don't have job protection. Before we get into the details of when you can get the leave and what the parameters are, we really want to flag for everybody that Connecticut FMLA is changing. As I said, the existing Connecticut FMLA has been on the books since 1996, but as of January 1st, 2022, it undergoes some significant changes. First and foremost, the employers who are subject to the law will move from those with 75 or more employees to those with 1 or more employees. So you've got a large population of employers who've never really dealt with FMLA before, who will have to under the new Connecticut law. The other significant change is the eligibility requirement. Currently, for Connecticut FMLA, you have to work for the employer for at least 12 months and have worked for at least 1,000 hours in the 12 months immediately preceding the leave. Under the new law, or under the revised law, there is no hours worked requirement, and an individual can get job protection after working for the employer for 3 months instead of the year. In addition to these changes, the length of the leave will change. Instead of 16 weeks in a 24-month period, it will now be 12 weeks in a 12-month period, with a possibility of an additional 2 weeks for pregnancy incapacity. Finally, Connecticut FMLA right now, like federal FMLA, says the employer can require an employee to use all of their accrued time off while they're out on a covered reason for leave. In 2022, the employer has to let an employee hold on to at least 2 weeks of their accrued PTO. You can't make them draw down their entire bank account of accruals. Next slide, please. So in terms of the reasons for leave, which are the same as the reason someone could get income replacement benefits, they look very similar to what you are used to if you've been dealing with federal FMLA. You can take leave to create or expand your family through the birth, adoption, or of a child, or taking a child in through foster care, which we call bonding leave. You can take leave to care for a family member with a serious health condition, which is usually called caregiver leave. Of course, you can take leave for your own serious health condition. And I just want to flag that a person's serious health condition includes serving as an organ or bone marrow donor and includes pregnancy. There are also 2 types of military family leave. One is the military caregiver leave, which is leave to care for a family member who's been injured while on active duty in the military. And the other is something called qualifying exigency leave. And this enables an employee to take time away from work for certain specific reasons associated with a family member's call to overseas active duty, such as taking time away from work to go to the sending off ceremony or the welcoming home ceremony, or to make financial arrangements necessary due to the fact that you've got someone going overseas. In addition to these leave reasons, which are all traditional FMLA reasons, Connecticut law also allows for family violence leave, which is 12 days in a 12-month or in a calendar year, where an employee who has been impacted by family violence can take time away from work to go to court or to receive treatment or counseling, or to relocate if that's necessary. So as I said, if you want to go to the next slide, Chris, these reasons look very similar to federal FMLA, but the definitions are different, primarily around what constitutes a family member. Under federal FMLA, and up until next year under Connecticut FMLA, an employee can take leave to care for a parent or spouse or a child who is under 18 or is over 18 and has a disability which impairs them from engaging in 3 or more activities of daily living. So it's a pretty high standard. Under Connecticut Paid Leave Act and under the Connecticut FMLA, as it will take effect next year, the definition of family is broad and includes not only the parent or spouse, but a son or daughter of any age, as well as a sibling, grandparent, or grandchild, or an individual related to the employee by blood or affinity whose close association the employee shows to be the equivalent of one of those family relationships. So what does it mean to be related by affinity? Well, it's a new concept for Connecticut, but it's actually a concept that the federal government has used for a few decades now in connection with federal contractor sick leave, as well as other leave rights like bereavement leave. Basically, it's a recognition that families don't all look like Ozzie and Harriet Nelson. So we want to recognize that you could have a significant personal bond with an individual that is like a family relationship, even though there is no biological relationship. And so those could be, for example, your great aunt who really played the role of your grandmother to you. You took care of her. She came to all your events, every holiday. She's essentially your grandmother, but she didn't bear your mother. She was your aunt. It could be a significant other who's you're not married to, but you live with and you share a spouse-like relationship, or any of those other examples. It'll be up to the employee to demonstrate the facts to support the employee's claim that this is a family-like relationship. So the other big questions we like to make sure everyone has kind of ready to go is, how long are these benefits available and who's eligible? So this slide is really kind of a one-stop shop to know how long you can take job-protected leave and receive income replacement benefits. If you're eligible for federal FMLA, if you're eligible for federal FMLA, you can take 12 weeks of leave in a 12-month period for all the leave reasons we already listed, except that for military caregiver leave, which is when the military member has been injured in active duty, you could actually take a 26 weeks leave. That's a one-time benefit. Connecticut FMLA, and we're listing the rules as they will be in effect next year. Connecticut FMLA allows for 12 weeks of leave in a 12-month period. It still allows for that 26 weeks of leave for the military caregiver. And as I noted before, you can take 12 days of leave for family violence, and you can also potentially be eligible for 2 additional weeks, so up to 14 weeks for incapacity due to pregnancy. Under the Connecticut Paid Leave Act, the paid leave benefits, the income replacement benefits, are available for up to 12 weeks for all leave reasons, including military caregiver. We don't have that extra 26 weeks, with 2 exceptions. We only pay for 12 days for family violence, but we also do allow the extra 2 weeks for incapacity due to pregnancy. So in the next slide, we just reiterate the eligibility requirements. So we've said federal FMLA, you have to be employed by the employer for at least 12 months. And this is, again, an employer with 50 or more employees. And the individual has to work for at least 1,250 hours. Under Connecticut FMLA, as it will take effect on January 1st, 2022, all you have to do is show that you were employed by the employer for 3 months. To receive income replacement benefits, we really don't look at how long you were employed by the employer. Since our focus is on the income, we actually look at the individual's earnings. The individual has to have earned at least $2,325 in the highest earning quarter when we look at the first 4 of the past 5 quarters. The legislation was intended to provide this income replacement even to individuals who may not qualify for job protection, and they wanted to make sure that it was expansive enough to help people who work 1 or more jobs, and so they may never hit eligibility if you look at just their earnings from 1 job. So we're required to look at all of their earnings from all of their employers. The other factor we have to look at is they either have to be currently employed and working in Connecticut, or they have to have shown that they were employed and working in Connecticut during the 12 weeks immediately preceding the request for leave. A sole proprietor or self-employed individual who's opted in and has been making contributions can also receive income replacement benefits if they can show that their self-employment earnings equal the $2,325 in their highest earning quarter of the first 4 of the past 5 months. In one of the highest earning quarter, looking at the first 4 of the past 5 quarters. So let's talk about what employers have to do, because I think it's important for employers to understand that they have an existing role that's going to change a little bit with the new Connecticut paid leave law and the changes to Connecticut Fmla. In general, and this is true right now, and it will continue to be true even more so next year, anytime an employee asks for time away from work for potentially FMLA qualifying reason, the employer should ask 2 questions. 1, is this employee eligible for job protected leave? And 2, is this employee eligible for any income replacement while on leave? Both questions should be asked every time because the answers could differ depending on the situation. So an employee could be eligible for federal FMLA leave only, potentially eligible for Connecticut FMLA only. They might be eligible for both federal and state, in which case the leave would run concurrently. Some employees won't be eligible for federal or state FMLA, but job protected leave could be considered a reasonable accommodation under ADA or pregnancy, disability, or CPAs. And there will be some employees who are not eligible for any job protected leave at all. Perhaps they're a brand new employee and they haven't even worked the 3 months, or perhaps they've exhausted their entitlement and need more time off, but they're not entitled to any more job protection. So those are the questions you ask to figure out if they're eligible for job protection. To figure out if you're on income replacement, Chris, the next slide. You have to really look again at the specifics of the situation. An employee may be eligible for income replacement through their employer's own policies, through their sick leave or vacation leave policies. If so, the employee may be able to receive benefits from both the authority and the employer at the same time. However, the combined benefits cannot exceed 100% of the employee's regular wages. If an employer offers short-term or long-term disability policy, you need to look at the terms of that specific policy to see if the employee would receive benefits from the policy first or from the authority first. Although we can tell you that typically those policies are written such that an employee would need to come to the state first and receive benefits from the authority. Under the statute, an employee who's receiving workers' compensation benefits, so the temporary total or so TTD or PPD, permanent, partial, or temporary total disability, would not be able to receive any benefits from the paid leave authority. There's just a flat out prohibition. As we've noted, employees could be eligible for income replacement, but not eligible for job protection. So you need to run that eligibility analysis, but then also tell the employee, you might be eligible for income replacement and you should really contact the paid leave authority. Just as a reminder, in case you want to use this as a standalone slide, employers are entitled to require their employees to use their accruals, vacation or sick leave or other PTO, but you have to let them hold on to at least 2 weeks of leave. You can't require them to exhaust their time while they're out on leave. So that's sort of the employer side. Let's look at what happens when the employee does come to the authority for benefits. The authority actually has a request for proposals out right now, looking for a partner to help us with claims administration. We anticipate using a third-party administrator to run this process. But we still have the employee come to the Connecticut Paid Leave Authority for the benefits. They'll make the application, and the authority or our TPA will validate that the employee is eligible for benefits by looking at their earnings from all of the Connecticut employers. We're working with the Department of Revenue Services and Department of Labor to be able to access that data. And we also need to validate the reason is one of the covered reasons. We will calculate the employee's benefit amount But because we have to consider if there are any employer-provided benefits that lead to an offset, we will be communicating with the employee and the employer to determine if there's any offsets from employer-provided paid time off, as well as to validate the employee's actual covered absences. An employee cannot receive income replacement for a day or an hour that they're actually working. So we need to validate their absences. I should note here that you could get income replacement for leaves of less than full time. So if someone is working a reduced schedule or is taking leave intermittently, they can come to the authority to make up the lost wages. And that's, again, absences we have to validate. And then we issue the benefit payments. So the formula for the paid leave benefits, Chris, is set forth in statute, and it depends on how much you earn. Just like the contributions are capped, the benefits are capped. So if you earn less than or equal to 40 times the Connecticut minimum wage, you can receive 95% of your weekly earnings. So looking at 2021, Connecticut minimum wage is $12 an hour. 40 times that is $480. So if you earn less than or equal to $480 a week, you receive 95% of your wages. If you earn more than that amount, you'll get the $480 plus 60% of the amount your wages exceed the $480. However, in all events, the total weekly benefit payment is capped at 60 times the Connecticut minimum wage. So if you earn less than or equal to $480, you receive 95%. If you earn above $480 but less than $720, you'll do this two-part analysis. And if you earn more than $720 a week, your benefits will be capped at $720. So here on the next slide, we have a couple of examples just to show how that works. Sometimes it's easier to see the numbers, particularly for an audience of CPAs. So if Mike is earning $375 a week, that's less than $480. So we just do the simple 0.95 times 375, and that equals $356.25. Deborah, on the other hand, earns $700 a week. So her entitlement will be based on $480 plus 60% of the difference between $700 and $480. And that's, in this scenario, that difference is $220. So we take 60% of $220 and add that to $480. And that's how we see that Deborah's benefit would be $612 a week. So just to put into practice the job protection and the income replacement, we have a scenario just to illustrate how that works. So here we have Acme, which has 100 employees working in Connecticut, so we know it's subject to both federal and state FMLA. Wile E. Coyote's been working there full-time for 10 years, so we're going to make the assumption that he's earned at least the 23-25 in his highest earning quarter, and thus is eligible for income replacement. And as an individual who's worked there for 10 years, we know he's eligible for job protection. He has 4 weeks of sick leave and 2 weeks of vacation when he gets injured and has to be out of work for 8 weeks. The employer says, all right, Wiley, are you eligible for job protection? If so, under what statutes? And what is your sources of income replacement? And that we can show in the next slide. Since he's eligible for Connecticut and federal FMLA, his job protected leave will start the first day he's out of work following the injury. And both the federal and state FMLA will draw down simultaneously. So here he's going to take out his 8 weeks of the 12 available for Connecticut FMLA and 8 weeks of the 12 available for federal FMLA. We're assuming that Acme is requiring its employees to use its sick leave accruals to reduce stacking. So we're going to have Wiley use his sick leave accruals for the first 4 weeks. The employer cannot require him to use up the last 2 weeks available to him of vacation because the statute says you have to hold on to those. So Wiley's going to come to the authority in week 4 and will receive income replacement benefits from the authority for the last 4 weeks. If Wiley gets injured or has to care for a parent or spouse or sibling later in the year, he will only have 4 weeks of job protection available to him because he's already used up 8. but he might have 8 weeks of income replacement available to him because he's only used up 4 of those weeks. Okay, next slide. Okay, the private plan alternative. So we've been talking about this Connecticut Paid Leave Program, which is administered by the authority, but the statute also allows employers to apply to use a private plan to meet their obligations in lieu of having their employees participate in the public program. If they have an approved private plan, the employer would be responsible for administering their claims for the income replacement. If you get an approved private plan, you do not have to remit employee contributions to the Paid Leave Authority, so that is excused. However, you are entitled as an employer to use that money for the purpose of administering your private plan. You cannot use the money for any other purposes. You can't just put it into a fund that supports all of your benefits. It has to be limited specifically to the private plan. And you cannot ask the employees to pay more than the contribution rate set by the Paid Leave Authority for the public plan. So on the next slide, you'll see just a screenshot. If you go to Connecticut Paid Leave Authority, ctpleave.org, and click on the tab to I want to apply for a private plan, you'll see the process as well as the policy and some checklists. But generally speaking, by policy, we mean the policy established by the Paid Leave Authority for the requirements for a private plan. Basically, the plan has to offer the same or better benefits. It cannot just offer sick leave, for example. It has to offer the family leave as well. And that's why short-term disability policies usually are not going to be sufficient, because usually a short-term disability policy is only for the employee's own illness. It cannot cost the employees more than 0.5%, and it must cover all of your employees, at least all of those working in Connecticut. You can't have a private plan for your executive suite and then ask the rest of the employees to participate in the public plan. Because the Connecticut Paid Leave Program is entirely employee funded, the legislature insisted that employees make the final decision. Therefore, there must be a vote of your employees. If they have to approve your private plan before you can apply. If you are interested in having a private plan, the first step is to register. That is the first step for everything. So you register as an employer under the ctpleave.org, and you check the box saying you're interested in applying for a private plan. Before you can actually submit your application, you need to find a plan. It can be either an insured policy or a self-insured plan. And we have information on our website about insurers that have been approved by the Connecticut Insurance Department to offer policies. We also have a template for a self-insured plan. You have to educate your employees about which plan you want to offer them. You have to provide the insurance document as well as a plain language guide explaining the proposed policy. And you have to hold an anonymous employee vote. The majority of your employees have to approve the plan. Once you've done all of that, you can submit your application. Because you've registered already, you'll have an account on ctpleave.org. So you go to your account, you click on your business name, and then there'll be a tab that says private plan or apply for private plan. And there'll be step-by-step instructions for how to apply. It's a relatively short process. You have to upload your plan document and your plain language guide and fill in some information about your business, about the vote, and attest to the requirements. So it doesn't take long. And then we will approve it. So I'm going to turn this back over to Chris so she can tell you about registration, because that is the focus of this month, is to make sure all employers are registered.
Great, thank you. So we wanted to walk through the process, which is a fairly simple process for getting businesses registered. And as Erin shared, whether it's private plan or just simply getting the employer started, we have a process to get employers registered, and it's a two-step process. We'll talk about what you need to do to prepare for registration, and that's really making sure that we have the employer's name and their FEIN number, and then working to go to the business.ct.gov website so that you can create a state of Connecticut account and then you'll be brought back to our website where you will complete your registration. So in the first step, as I mentioned, you will go to the ConnecticutPaidLeave.org website. That is your starting point, and you'll see where to register. And again, being ready for that information that you'll want to have is, again, the Federal Employer Identification Number, the North American Industry Classification System Code, or the NAICS code. And then on our website, just know that for third-party administrators, employers, we have lots of information and tutorials about how to register. It is a simple process, but just know that there are lots of good educational materials that are available right there on the site. Once you get to our page, you will go and you will get started. Key thing that we share with everyone about registration, please make sure that you are using Google Chrome or Microsoft Edge or Firefox as a browser. Internet Explorer is not supported. And so the first step, as we mentioned, you'll be going to get an account created on ct.gov, which establishes a state ID. And that state ID is intended to be used for future use with other agencies as a one-stop for initial set of credentials with the state of Connecticut. Those employers that already have user IDs with the Department of Labor and Department of Revenue Services, those credentials will not work in this scenario for registering with us. But the roadmap that is in place for ct.gov is to create an initial set of credentials that will be used over the years as a one-stop shopping for employers to come to. There's a roadmap to get there. And we, as a Connecticut Paid Leave Authority, are one of the first agencies that are taking the benefit of using those single sign-on credentials. Once your credentials have been established, you will come back to the Connecticut Paid Leave.org website and you will be able to sign in. I will say this, when you do go to the first step where we have get started and you get those credentials set up through ct.gov, you will receive an email that will come to your email acknowledging that you've sent and created credentials. Please click the verify link on that email right away. We've learned through the registration process that sometimes people wait to click that acknowledgement, but it's really important to go ahead and click that acknowledgement because it lets us know that you've affirmed that you've received it, and we can continue with the registration. So once you have those credentials established, you will come back to the ConnecticutPaidLeave.org website, and then you will click on the link that then says Get Started. When you click that again, it's now going to recognize, and you'll see Register. And because when you click Get Started and you put your credentials in, we know that you have already established your credentials with the ct.gov site, and we can start the registration process on our side. And so now that you're on our website and you're beginning the registration process, we're going to look for several pieces of information. One, we want to know who the contact information is for that employer. And then we also want to get the FEIN number. We do have a search facility there on the site where you can search to see if the company was already set up. Because you all are CPAs, your employer may have already gone in to register their business. So you do want to go in and use the search facility to see if they in fact registered. If not, you would want to move forward with the registration. The next step is to add additional business information. And in that, the screen will bring up demographic information that allows you to put the business location, and then also it asks for information around payroll size of the employer. And then finally, in step 4, you'll also see the ability for the employer, or if you are registering the employer on behalf of the employer, if that employer wants additional users to have access to the account. And so we find that sometimes a payroll processor or a person who is an administrator on behalf of the employer is setting up the business, but perhaps there's one or two people in the office that they may want to have access to be able to submit information on behalf of the employer, and you can put that additional person's names, both their name and their email contact information. After all that's done, you'll be able to simply review and then submit the information, and you'll receive an acknowledgement from us. So the process is fairly simple. I will just quickly go through some of the screens of what it looks like. Again, just recapping, you'll be at ctpaidleave.org website, and when you click Get Started, it's going to bring you to this screen. And this is where you're going to put those credentials in to establish your ct.gov credentials. And then once that's done, and you come back and you sign in, you'll now be brought back, as I mentioned, to the Connecticut Paid Leave website. This is going to be where you'll put the account information. And I know that the screens are small, but you will be receiving this presentation, and it'll show you all the information for the screen. You will register your account, and you'll put in all the critical information. As I mentioned, the additional business information, which tells us about the size of the business, the size of the range of the payroll, the number of employees, and then finally the additional users that you may want to have available to the account. Again, when you finally complete all of that information, you will see both on screen and email an acknowledgement that your registration has been completed. And in this acknowledgement on the screen, there will be a Connecticut Paid Leave registration number. Some of the questions that we receive is if the employer has done their registration, they feel, oh, I must have, give this to my tax accountant. They can, but just know that in our database, and for us to look up an employer, we both can have the registration number, but most importantly, the tax ID number, the FEIN number, is the number that we will be able to always look up the employer. So I want to just share a little bit of additional information around helpful resources that we have developed that are available to you and to employers. On our website, again, ctpaidleave.org, there is a tab called Resources, as well as in the Employer section of the website. And we have developed several, these links will be live in the presentation, but we've developed several key artifacts that you can use. We have an employee rights poster, which is really speaking to the employee about what their rights are from a Connecticut Paid Leave and Family Medical Leave perspective. We have an employee RAC card, which is an abbreviated version of the data, but it's meant to be a very narrow card that can be printed. All of these are available in PDF format, so you can use them with your electronic communications to your employees, or on the bottom here is an employee paycheck mailer. We know that sometimes companies are including these mailers with their check distribution, or even in their newsletters. There's an employer toolkit, and the toolkit goes through all of the types of information that we've shared today and links to critical information. And then finally, an employee fact sheet. And that fact sheet is a quick two-pager that is easy to, again, be printed off and available to employees explaining the program. So with that, just a couple of key reminders that we want to continue to share with you. I know we're going to start Q&A in just a few seconds. Really, takeaways from today is please continue to work with your employers and remind them to get registered, or if you are registering on their behalf, please register your business as a CPA or as an accounting business. And then also in that, then you can go ahead and continue to register employers if you're doing that on their behalf through our website. If you are working with a payroll provider or a payroll provider that supports your organization, please make sure and contact your payroll provider that they're already processing the wage withholdings and in our position to remit the withholdings which will be due at the end of the quarter with a 30-day grace period. Again, those holdings are going to be remitted and will come into the Paid Leave Authority Trust Fund, as we mentioned. And so it's critical that if you are supported by that payroll provider, that they are aware of this. And then finally, to continue to educate your employees about the withholding, or again, if you're supporting an employer, that you share this information or the information from our website and all the resources that are available. And then finally, please always check our website, ctpaidleave.org. We are almost every 2 weeks updating the website with additional frequently asked questions, new functionality. This past weekend, we just finished an implementation and being positioned for getting information from those employees that are going to be submitting private plans. And so please come back regularly to our website. And then finally, on our website, we do have another section right at the top, which is called Contact Us. We receive lots of questions. We are a contact center, so we are not a call center, but we are a contact center where if you have questions on behalf of the work that you're doing from an accounting perspective, or your employer has a question, please put that through our Contact Us portal. We have a very supportive and timely team that is getting the inquiries and getting back to all of the submitters on their questions and are just a great resource for helping to get your questions answered. And then as I mentioned, we have a robust frequently asked questions section. And then the website has been stocked with lots of great videos explaining the parts of the program, how to register, the differences between the family medical leave and Connecticut Family Leave laws. So please use those videos also. And again, we will continue to add informational videos as we go throughout the program. So I think we'll stop here from a slideshow perspective and pivot to our Q&A. And I will stop sharing. Well, I won't stop sharing.
Hi, Chris. Thank you so much
If you
for
could
that.
stop sharing your screen, that would be great, Chris.
I would like to take a moment just to submit the poll for the group again so everyone can answer those poll questions. So I'm going to give everybody a minute to answer those poll questions and then we will wrap up that section. All right, everyone. So that poll should be in progress. Please respond to that poll. If you have responded already, please respond again. So the poll captures everyone's questions and answers. Again, everyone who's still with us, the poll is in progress. So please answer the questions on the poll as they relate to you. If you have answered already, please answer again so we can capture everyone's information. Thank you. And we'll be wrapping this poll up in about 30 seconds.
Should we go to the questions?
Yes.
All
Amber,
right, thank you, everyone.
You're set with the poll, Amber?
Yes, we are. Thank you.
Chris, we received a couple of questions asking about how to actually make the payments at the end of the quarter. Do you want to take a minute to explain the two options?
Absolutely. Thank you. Thank you for covering that question. So there are two ways that we will receive payments from employers and third-party administrators. So we've been working very closely with the National Payroll Consortium that supports many employers that submit their payroll today. And what will be enabled is at the end of the quarter, and as we shared, end of the quarter with 30 days after. So April 30th, payments can be remitted to us through a batch process, a secured transfer protocol batch process, where the payments will come in from payroll providers, and those payments will go directly to our bank, which is Bank of America. We will get those payments, and then we will get those tracked into our employer contribution platform so that we have a record of those payments from each employer, again, tracked by their FEIN number. For those employers that are not supported by a payroll provider in that manner and perhaps manage or you manage their payroll for them, we will also have a web portal capability where you can come in again, through the registration that we just showed you. You would log back in. The employer will have a section of the site under a feature called My Account. And under My Account, there will be ability to file and pay. And file and pay will allow the employer to put in for the pay period that they're reporting for, the number of employees that represents, the total wages that represents, and then our system will calculate the 0.5% that is due for that reporting period. Employers that choose to, some employers have said to us, well, we don't want to wait until the end of the quarter. We would like to pay as we go or as our payroll is being processed. And that can be done also. And so you don't have to wait till the end of the quarter. We are finalizing right now the testing and the process with our payment processing capability, both for batch and for the online portal. And that we expect will be turned on much later this month. We will have a communication that goes that says it's ready for us to remit the payments, either through the batch or through the online portal. So again, you will have two options through our portal, through ctpaidleave.gov, registering. After you come in and you've registered, you'll be able to go there and there'll be a feature to file and pay on an individual employer basis, or secondarily in a batch mode, typically through a payroll provider.
Thank you, Chris. There were 3 questions that came in that really wanted more specific information about who's required to contribute. The first one asked if a corporate officer who is the sole employee of a company, probably an S Corp, is that considered to be an employee? And the answer is yes. If you've set up your organization so that the owner is also a corporate officer who's an employee receiving a W-2, as opposed to taking a draw and paying self-employment taxes, then they're considered an employee. So if you're basically, the short answer is if you're an employee for purposes of payroll taxes, we consider you to be an employee. Related to that was a question that pointed out that a spouse of a sole proprietor is not considered an employee for purposes of unemployment, and wondering if the spouse is covered under our law. And the answer is yes. Again, we don't actually use the DOL unemployment definition to determine who is considered to be an employee. We don't have the same exclusions in our statute as the unemployment statutes do. So if that spouse is an employee of the organization, is receiving a W-2, then they have to contribute. And the third related question was, what if you earn less than the $23.25 per quarter? Do you still have to contribute? And the answer is yes. There is no minimum payroll that is required to be subject to the contribution obligation. And the reason for this is because the legislature wanted to make sure that individuals who worked multiple jobs and perhaps didn't earn very much in any one job could still access benefits if they had a qualifying reason. And the only way to do that is to make sure that everyone is contributing from all of their jobs. And so you may have individuals who don't earn the 2325, but they are subjected to the requirement to contribute the 0.5% of what they do earn.
All right, I see another question here. Can I register multiple businesses under one business.ct.gov account? So the answer is yes, but I want to just be clear about how to do that. So you would be establishing in that instance yourself as the accounting business with the business.ct.gov accountant credentials, and you would establish yourself as an accountant. After you registered your own accounting business, then you have the ability to say, after you finish your registration, there will be a button that says, would you like to add another business? And you will say yes, and then begin to add those other businesses. And when you register those businesses, it will ask what type of business it is. And it's important in those instances, you've already registered your accounting company. Now you are registering on behalf of employers. And so you will begin to list those employers by their FEIN number. So let's just say you have 10, you would just continue to keep adding another business. Just make sure that you're not listing those businesses as a tax accountant. And I say that because we're going through a review right now where tax accountants have come to the site and have done great registration, but they're adding the employers that they support and listing them as tax accountants. So you want to list those businesses as employers, but you are registering on their behalf. So the answer to the question is yes, you can.
Okay, we've got a couple other questions about who's an employee. Seasonal workers are employees, and they are subject to the contribution requirement. There's a question about an individual who is a senior who works part-time and also collects Social Security. They do contribute. The fact that an individual receives Social Security does not preclude you from receiving benefits. So they're working part-time. They contribute based on their part-time wages. They don't contribute based on their Social Security, but they contribute based on their part-time wages. And then if something happens where they can't work that part-time job and they've met the income requirement, they can receive benefits. There's also a question about a priest who's an employee of the church. What do we do with them? You all know this because you're CPAs. We learned this as part of our standing up the program. There are very special rules for members of clergy, and so we actually have an FAQ on our website. But basically, to the extent that a priest is receiving W-2 and is paying into FICA, then they make their contributions. To the extent that they are treated as self-employed, then they don't have to contribute. This question also asks if the priest is covered under a private plan offered by the Archdiocese. I have to tell you, we have not yet seen any applications from any of the Connecticut Archdiocese for a private plan, but if they do, we'll let you know. But that will be similar to a question they answered in the chat already, which is if you have, for example, multiple employers, one of whom has a private plan and the other one doesn't, then you're basically, for purposes of income replacement, kind of bifurcated. You would go to your private plan employer for income replacement for the wages you are no longer earning associated with that job. And then you could come to the paid leave authority for income replacement for wages you aren't earning in your other jobs that are not private plan. So you just sort of deal with it that way. We also received a question about what if you don't have any payroll for the first 3 quarters? And I don't, okay, there's the rest of it. But pays bonuses in the fourth quarter. Does the business have to file anything? We're going to tell you to enter in that you have 0. Chris, tell me if I'm wrong, but I think we tell you to enter in 0 in your quarterly payroll amount. And then you would and we would know then that you don't owe any contributions for that payroll. This is definitely a situation where seasonal employers may not have anybody, you know, if you work for a golf course, you may not have anybody employed right now, but you will have people employed starting in March or April. And so you would just put 0 for the first quarter and then make your contributions for the remainder.
There's another question piggybacking on the quarterly submissions. Is there a form that is filed? Most quarterly or annual payrolls includes a filing form. So no, we do not. If you go to our website and you're remitting the quarterly payment, you are completing everything on our online screen for the information that we need to receive. And when you submit and remit the payment, that is all that we need. What we do recommend to employers and also the accounting agencies is that you all keep the supporting detail that went behind that quarterly submission for tax and for audit purposes, but we are not requiring an additional form to be submitted.
So we also received a question. Sorry, there was one that said, so as an accountant or CPA, I can register my clients, and the answer is yes. And then there's this related question: is what happens if the client changes accountants at some time in the future? Well, either the client or the accountant will go back in to their account and just update the information. We built the website so that the employers, the accountants, the third-party payroll processors have the ability to do a lot of the changes themselves rather than having you have to submit a request for us to update your information. So you just update it. You can also update if your staff changes, right? We wanted to make it easy for you because we recognize that staffs change, names change, and emails change. So that's all very easy to update in your own account.
I would also, as you visit our website, ctpaidleave.org, please click on the section that is for third-party administrators or payroll providers. A lot of the role and the function of what you may do for your employers, we have lots of great information in that section about doing information on behalf of an employer. So a lot of your questions, we have videos, we have job aids. I think they'll answer many of your questions to those functions.
I'm just going through to make sure that we're answering all the questions. One question, are benefits considered taxable wages? Yes, they are. And an individual who's receiving benefits can request from the authority to have their withholding taken out. That is something that they would have to request of us, but it can be done. We also got a question that asked, why would anyone do the bother of a private plan? And that really depends on your situation. It is a lot of work to offer a private plan. We don't want to minimize that, but we do recognize that some businesses already offer plans that cover all the same reasons that we cover, or almost all. And so it'd be really easy to just adjust their benefit plan to offer the 12 weeks of income replacement at the same contribution level for the same benefit amount. And they would rather have it all handled internally, and they want to do that. Some employers work for or have staff in other states. And so if you have staff in New York or New Jersey or Massachusetts or Rhode Island, you are already subject to their paid income replacement laws, and you may already have a private plan. And again, it's just easier to adjust that. So it's up to you. What we do say, though, is under the statute, you have to get permission from the authority, and we have to validate that your private plan meets the statutory requirements and that your employees have voted for it. So you can't just do it. You have to get permission. But if it's something you want to do, that's your option. If you'd rather just remit the payroll to us and have us handle the payment of benefits, that's fine too. So I'm Missing any? I'm trying to go through and make sure we've captured all the questions.
I think we haven't answered the question around are there late filing penalties or interest? Penalties if you do not file a zero payroll. So if you have a zero payroll, we want to know that. By statute, we can apply penalties and interest for late payments. We have been working very earnestly with companies to make sure that they get registered and work with their payroll companies so that they can get the process started. And I think if there is a delay or having worked with the payroll company, we cannot go back more than 1%. I think it's 1%, Erin, right? In terms of trying to catch up any contributions.
Yeah, we've worked with it. So under existing law, right, employers are not allowed to just willy-nilly take deductions from the employees' paychecks unless there's some sort of statute that permits it. Our statute requires employers to take the 0.5%. But if they're late, if they haven't quite got their system up and running yet, we wanted to give some employers a little bit of flexibility. So Department of Labor has agreed that you don't need a specific permission from the Commissioner of Labor to take up to 1% as a catch-up payment. So you missed you missed one payroll cycle, you could take up to 1% at the next payroll cycle to catch up. That grace period is only open for the first 2 quarters. So until July 1st. So we want to just make sure that everyone has time to get everything in, make sure that the contributions are in, but we also don't want employees to bear the burden of having a giant deduction taken out of their paycheck when they weren't expecting it. So that's why we have this grace period. And that's actually one of our FAQs on our website. So you can use that to explain to your employees what you're doing. We also got another question about the tax reporting form. Specifically, will you be preparing some tax reporting form like a W-2, or will we need to adjust our W-2s? So for purposes of the contributions, you will need to capture those contributions on the employee's W-2s. Department of Revenue Services suggests using box 14 as the place to put it so that your employee, so you can show and your employee can show that the deduction was used, was sent to Connecticut Paid Leave Authority. And if your employees do itemized deductions, they can use that W-2 to support the itemized deduction. It's basically the equivalent of a state tax, so they could list it there. When they get their benefits, we will be issuing a 1099 for the benefits. So there's also a question here about the job protection. Specifically, it's very difficult if you're a small employer to hold a job open for 12 weeks. And what do you do? So we recognize that is certainly an area that we understand. The statute is very clear that the job protection is something that the legislature wanted to extend to employees of small employers. The statute does say that if you take on an employee on a temporary basis to fill in while you've got an employee out on leave, and then you have to let go the replacement, your unemployment rating will not be affected by that. So that's a measure of protection. The other thing I would say is that, as we mentioned, the obligation to at least consider job protected leave as a reasonable accommodation applies even to employers with as few as 3 employees. So it is something that employers should have been thinking about, should have been aware of, but we recognize it, and we just are here to try and provide as much information so employers know what their obligations are, and we're working with DOL to provide more information about how to actually administer these leaves. So that's something that we'll continue to work on and continue to offer classes and information about.
All right, I think someone is asking us to talk about clergy again, or priests, whether or not they're covered or not.
Yeah, sorry, my answer may have been unclear because it's just a tricky situation. A member of the clergy may be an employee of his or her church, or may be considered to be an independent contractor or self-employed individual, or may be considered to be a hybrid. So the answer is we're following the IRS rules. And I don't remember the circular, but it's on our FAQs where we specifically reference the IRS circular that relates to this. And the short answer is, to the extent they're treated as an employee for tax purposes, they will be required to make contributions. To the extent that they're treated as an independent contractor or self-employed individual, that's how we'll treat them too. There was another question that said, look, there are certain people who don't pay into FICA. Do they still have to contribute? And the answer is yes. So the FICA cap is really a proxy for making sure that people have, that their contributions are limited, just like the benefits are limited. But if you are not subject to FICA, then your contributions will be based on your total wages, because frankly, a person who's not subject to FICA is not receiving the kind of cafeteria plans or other benefits that you would exclude, which is the whole reason for identifying the FICA number to begin with. So if you pay taxes, if you are an employee for purposes of payroll taxes, H-1/2 visa, student worker, household employee, you are required to make the contribution. There is a question about whether the employer can make the contributions on behalf of the employee. We know that a lot of employers are interested in this, and the answer is not exactly. So the statute says it's the employee's obligation to make the contribution. If the employer wanted to say, hey, Aaron, I don't want you to have to pay for this contribution. I want to pay it myself. What the employer is doing is actually giving a benefit, a taxable benefit to that employee. And so if they really wanted to hold the employee harmless, what they'd have to do is gross up the salary by the contribution amount plus the taxable benefit of that extra contribution amount. You can't just say, oh, Aaron, your 0.5% would have been equal to $50. I'm giving you an extra $50. Got a question about construction employer with employees in multiple states for various jobs. Who and when is an employee who's subject? So I'm going to be really precise about this because it's an area that requires precision. You are an employee subject to Connecticut Paid Leave Authority, to the Connecticut Paid Leave Program, and required to remit 0.5% if you are an employee working in Connecticut. We determine if you're an employee by looking at what your tax status is. We determine if you are working in Connecticut by applying unemployment insurance principles. So we're going to say that this is a construction employee because we've made that determination based on the fact that the construction employer is issuing W-2s to the employees. Do they work in Connecticut? We're going to say, okay, where do you pay unemployment insurance? If you pay unemployment insurance in Connecticut, they're working in Connecticut. If you pay unemployment insurance in Massachusetts, they're working in Massachusetts. If you don't pay unemployment insurance, which would not be the case for construction, but is the case for some other employees, we're going to apply the same principles about looking at where they do their work, where they receive direction and control, and the locus of the business. And we have an FAQ that details those requirements on our website. Chris, I'm just going through and seeing if we have any others that haven't been answered. I'm not seeing any.
I think we got to all of the categories. There were several on household employees, but I think we've done those. The agricultural workers, I think we also, those the seasonal employees. So
and you did talk about
that.
Penalties. Did we talk about the credentials? Okay. And you talked about business one stop.
Oh. Yes, we did.
Okay. So yeah. I think we've gotten I've gone through all the questions, either live or written down. I know Amber's been asking everyone to make sure that their questions are in the Q&A, but I'm just going to quickly check the chat while we give anyone sort of last call for questions in the Q&A.
Yeah, I don't think there's anything in the chat either.
No, looks like it. So as a reminder, if you haven't registered, register. If you have clients, tell them to register. That's the registering now and starting those payroll deductions is the single best thing you can do to make sure that you and your clients are in compliance. As we said, we do have that little grace period, but the longer you wait, the harder it is to qualify. And at the end of the day, if it's the employer who hasn't taken the steps necessary to remit the contributions, it will become the employer's responsibility to pay the contributions on behalf of the employee. And so you run into all sorts of tax issues associated with that. And it's not meant to be the employer's responsibility. It's meant to be the employee's. So please register, start taking those deductions. And as Chris said, go to ctpayleave.org. Make it a favorite. Visit us frequently. Check out our FAQs, our videos, and contact us if you have any questions. For those of you who are in Connecticut, I hope that the storm is treating you okay. I keep looking out the window and seeing that it's still snowing. So I hope that everyone stays warm and stays healthy. And thank you very much for inviting us today.
Thank you all.
So thank you again to the authority for putting on this presentation today. Thank you for joining us. Again, if you have any questions, visit their website. If you have any questions for Connecticut Society of CPAs, don't hesitate to call, email, reach out, and someone will get back to you. You will receive CPE credits for today's presentation if you answer the polling questions. And other than that, thank you again so much and have a great afternoon.